Hello and welcome to the attendees for this seminar. My name is Charlotte. I'm the chair of the Oxford Children's Rights Network, and we're just going to give it a few more minutes because we still have people joining before I pass over to Hoko. So thank you very much, and if you just hold with us for a few more minutes. Okay, well, thank you very much indeed for attending the second Oxford Children's Rights Network seminar this term, and we're delighted to be back hosted virtually by the Bonavero Institute. So many thanks to them. And I'm particularly excited today to welcome to speak Dr. Hoko Hori, who is a lecturer at the University of Leiden. She is somebody who's been interested, I know, as a personal friend for many years in children's rights, and most excitingly, last Friday, her first book was published, details of which we will be circulating, Child Marriage, Rights and Choice, Rethinking Agency in International Human Rights. Hoko is studying the concept of agency at the moment, expanding out to look at the background and practice of age of consent laws in 3 countries, Japan, Indonesia, and the Netherlands. She previously completed her PhD at Leiden University. So I'm delighted to hand over to her.
Thank you indeed, Charlotte. You did a perfect introduction, so I don't need to do anything else anymore. You even did a book promotion that I was told to do by the publisher. So thanks a lot. And I will, so that I can now, thanks to you, I can just go straight to start the presentation. So I hope you see the PowerPoint. Charlotte, you can see it now?
All looks good, yes.
Yeah, okay, thanks. So let me start by the presentation with a little story from a few years back. So I was sitting at the audience, as an audience in a seat at Girls Advocacy Alliance event in Amsterdam, where they introduced their project as aiming to support girls in Africa in having their own voice to be heard. So that was the concept of their project. And this suggests to me that the ultimate goal is to support their choices, right? That's the topic, that's the concept that I want to talk about today. Their representative was a girl from Ethiopia, and she was selected to be heard in Geneva. The girl was chosen because she could tell vibrant stories of why she opposed child marriage practice with capacity and confidence. That's what they told us. So while they emphasized her and other girls' choice and voice not to marry, discussion about children's choice and agency to marry was simply absent at the workshop. So I tried to raise the issue and ask what their approach is to children who themselves say they want to marry. And in their reply, they said their constant dialogue with local communities to change customs and traditions. They said it is difficult to fight with that kind of perception. So in their eyes, children cannot possibly want to marry, so they blame such scenarios on bad customs and traditions that they need to combat. And this story shows the two contradictory views on agency. While they emphasize certain autonomous choice made by women and celebrate when girls exercise their agency not to marry, they do not recognize children's agency to marry. This is, of course, in line with the approach of international institution and framework. So they try to ban child marriage because they assume that children under the age of 18 are incapable of choosing to get married. But the question here is, are they really incapable? If they are, why would they be capable of choosing not to get married? So with my book and research, I show that the international child marriage framework influences transnational and national policies and programs, and human rights advocates such as the Girl Advocacy Alliance work within this established framework. In this sense, human rights law and discourse produce particular practices. They provide specific rules and directions that CSOs and the policymakers to follow. However, these laws and discourses are also a product of a specific way of thinking about development, progress, and freedom. So I explore the puzzle of agency within this framework and try to understand what choice means for international organizations and children themselves. So here my aim was to offer a perspective and create a space for discussions about this topic, this maybe uncomfortable topic of choice in child marriage. So the central question of my book is why children marry. When asking this question, I consider both subjective and structural reasons. Subjective reasons, I mean, by subjective reasons, I mean what for them, for children, are the reasons to get married. So it's about what they feel and what they describe to me. When I interviewed the teenagers who got married before the age of 18, I was interested in their account. I focus on their subjectivity, which I consider the precondition of agency. I do believe that focusing on children's subjectivity in research can offer new ways of understanding and explaining children's experiences. And this is especially urgent in talking about child marriage. But of course, it is also important to analyze and read what are the factors behind their will, decisions, desires, and wants. So this question also considers structural reasons why children marry. That, for instance, are the structural reasons, for instance, are poverty, like many international organizations, presents as a main driver of child marriage, or oppressive culture, like what the Girls Advocacy Alliance from the story that I just told at the beginning was telling me. And also could be a lack of education, could be one of the structural reasons why children marry. So there comes the second question. I approached to examine this structural reason by analyzing how the practice of child marriage sits within the multiple normative and legal frameworks that are in place, and how actors at each level are dealing with different set of rules in the context of normative and legal pluralism. So I started from analyzing child marriage discourse at the international level, then moved to discuss the political contestation over child marriage at the national level. There, I use a case study on Indonesia, where the tension over the issue arises between the conservative Muslim organizations and liberal groups of human rights or women's rights advocates. And to zoom in further, I investigate child marriage as a social practice on the Indonesian islands of Bali, where I conducted ethnographic fieldwork over 6 months. And this is what I called a multi-layered analysis of socio-legal conditions at the international, national, and regional level. This is a socio-legal study in which my analysis mostly relied on empirical data that I collected through my anthropological fieldwork in Indonesia. So it does not only depend on legal and textual analysis, in that it is already, so in that sense, it is already interdisciplinary, but I felt that I need to go more interdisciplinary in order to analyze why children marry and in which conditions they make choices, because I engaged with 4 key concepts, which is agency, structure, modernity, and tradition. That's for me to be able to use these 4 key concepts, I felt that I need to turn to the literature from anthropology, sociology, social psychology, feminist philosophy, and post-colonial studies. So, and engaging with this different literature from different fields of study really opened up a new horizon of analysis of my data. And I will explain more about these concepts and my analysis later. And also, the interviewing children is considered difficult and was difficult, both practically and ethically. So ethical research involving children, which is called ERIC, is an international guideline for researchers who want to conduct ethical research involving children. And it covers 4 main concerns. 1, harm and benefit. 2, informed consent. 3, privacy and confidentiality. 4, payments and compensation. And they are all just simply important issues to consider in any anthropological research, not only the one involving children, but some need a particular attention when research informants are children. So for instance, one of the issues is informed consent. So while some might ask whether children are capable of providing consent to research at all, other studies challenged such assumption by showing that children, including those who are very young or having learning difficulties, can make informed decisions when provided with appropriate information by the researcher. So it seems to me that resolving this issue of informed consent from children is less about determining whether children are capable of providing consent, and it is actually more about whether researchers can provide information in a way that children understand the consequences of their consent. And of course, informed consent is also about taking into account any power imbalances in the relationship with our informant. So I paid particular attention to signs of reluctance because I assumed that it might be more difficult for children to express unwillingness due to lack of experience and their perceived social position. And this is interesting because these relational aspects shall be carefully considered when listening to children's voices, but the intention of protecting children, that my intention of protecting children, if taken too far, could also result in the liberal paternalism, which is exactly what I challenge in this research. So the challenge that I encountered in my interviews with the child informants was actually really at the heart of my research. So that's why I took some time to explain the method before I moved to the contents. And now I want to start talking about the content of the book and the research. And in order to listen to children's voices, we need to recognize them as subjective agents. And this is not as self-evident as it might sound, because it was only in 1970s when scholars started to challenge the assumption embedded in what is implied in the conceptualization of a child. Before, children were regarded as a passive object for protection with neither voice or agency. And the whole field of childhood studies emerged by orienting studies on children toward the social science, and they started by recognizing them as an active agent worth studied in their own light. The sociology of childhood has experienced the paradigm shift by regarding children as active agents and recognizing their voices. And this shift is also reflected in the UN Convention of the Right of the Child. Article 5 of the CLC incorporates the concept of evolving capacity. The more the child knows, experiences, understands, the more directions and guidance should be transformed into an advice. Then finally, it should eventuate an exchange on equal footing. So that's what the Committee on the Right of the Child says about Article 5 on evolving capacity. And Article 12 of the CLC stipulates that the right to be heard, which requires that the state parties ensure that children have the right to express their view freely, and that due weight is given to those views in accordance with the age and maturity of the child. And considering this increasing attention paid to children's agency, both in the international instruments and academic literature, we see that the current child marriage framework does not necessarily reflect children's rights as laid down in the CLC. Because the standard approach of the child marriage is to ban all child marriage regardless of what the children themselves are saying, because they are deemed incapable to decide to marry under the age of 18. And all the institutional efforts in relation to child marriage have been based on this strong and persistent assumption as well. And when we dare to put this assumption in question, the whole new picture emerges, and like that there are a lot of different reasons for children to marry. So the case studies of child marriage from my fieldwork shows how some children exercise their agency and capacity in deciding to marry. By children, I'm using the definition of international framework, which defines children under the age of, as those under the age of 18. But my informants were mostly in their mid to late teens. And in most cases, these teenagers themselves decided to marry, unlike the common image of child marriage as forced marriage. But of course, them not saying that they were forced to marry does not mean that it was an agentic act of them to marry, right? So determining whether the decision to marry was truly an agentic act or a forced or maybe a constrained one needed a careful consideration. So I made analysis by paying attention to what I call relational and situational constraints. So I will explain these two constraints that I categorized. For relational constraint, I looked at the power dynamics among children, their parents, their extended family, and local leaders, and how these power dynamics affected their decision making. For instance, Swasti it's not a real name, but who became pregnant at the age of 15 from an intercourse with her boyfriend, felt she had to marry because of the strong social norms in her rural village that she lived in Bali. She and her family would have lost the crucial part of their relational and social life in the village if she had given birth outside of wedlock. So as soon as she was pregnant, she needed to get married. And so that was the relational, that was one of the relational constraints that I considered. That was one of the example of it. And for situational constraints, I looked at the options children had at the time of decision making. So for instance, Ayu, who married when she was 15, lived in a difficult situation with poverty and no education. And then we could maybe say that she did not have much other choice than to marry. But interestingly, she was the one who I saw the most proactive in her decision to marry with her boyfriend. So her parents actually did not want her to marry yet, but she married by eloping with her boyfriend around the same age. So while this case shows that while the difficult situation requires special attention, it is also important to acknowledge that it is not impossible to exercise agency under such conditions. Ayu told me that I'm more free when I'm married. I do not have to work and raise money, so I can be lazy at home. That's what Ayu told me when I asked the reason why she married. And she seemed to be aware of her life options and chose what she felt was her best option, even though her expectation of married life later were proven wrong. And it's not like she can be lazy at home, but she still needed to work and things. But that was what she felt as the reason why she wanted to marry at the time. The cases also showed that at least 11 out of 16 cases of child marriage that I studied are caused by an unplanned teenage pregnancy. 2 of the other cases were caused by a fear of pregnancy, such as this case of Krishna and Suri that I'm going to introduce now. So Krishna and Suri had been in a relationship for 2 years. They lived together in an apartment in Denpasar for 3 months when they decided to marry. Krishna, the boy, was 15, and Suri, the girl, was 17 when they married through the customary ceremony. Their cohabitation was unsettling to Suri's family because they worried that she might become pregnant. To ensure that Krishna would be responsible for the consequences of a possible pregnancy, Suri's family insisted that they marry. Suri also said, "My family wanted me to marry to avoid shame in the village, as neighbors and relatives already knew about our relationship." And Krishna's father, the boy's father, initially disagreed with the marriage, arguing that Krishna was still too young. Remember, he was 15. However, Suri's family insisted, and eventually they got married. So this story and many others show that social unacceptance of premarital sexual intercourse and inability of tools for reproductive health are the core factors why teenagers marry in Indonesia. Given that many adolescents worldwide live in societies where premarital sexual and romantic relationships are taboo and sometimes even crime, marriage is sometimes a way to have legitimate sex to gain sexual autonomy and moral legitimacy in a society that they live. So obviously, I do not have time to introduce all the cases, but when I listen to these young couples who married, it becomes evident that many of them decided to marry for different reasons, such as love, desire, to belong to the community, and for new opportunities and hopes. And these subjective reasons for why children marry have been largely absent from the human rights discourse because the structural reasons silence these subjective reasons. I have pointed out the forms, reasons, and consequences of child marriage is much more diverse than how international human rights present. The next question then is, to what extent the current strict, rigid, abolitionist approach of international human rights institutions to ban child marriage is effective? For instance, women's and children's organization in Indonesia have been advocating to raise the minimum age of marriage in Indonesia, and recently the Constitutional Court in Indonesia has decided that the age will be raised from 16 to 19 for girls. And this means that more than 1 million people who would have previously registered their marriage will not be able to register their marriage under the new law. That, of course, includes those who really needed to register their marriage urgently because of unplanned pregnancy. If you cannot register your marriage, your baby is also often left unregistered, and it affects their legal identity and rights that they had. It also affects the rights of these women or girls who wanted to register their marriage, because without the state registration of their marriage, they also do not have rights that are ascribed under the state law, such as divorce and child maintenance. And I'm talking about state registration of marriage here because in the pluralistic legal system in Indonesia, you can marry even under the minimum age of marriage. That means that even if they cannot register their marriage under the state legal system, they can they can and will continue to marry under the customary system. These marriages will simply, marriages that has been conducted under the customary system will simply go unregistered under the state system. I also observed that there are plenty of ways to go around the state law and resort to illegal way to register their marriage, such as using fake documents. So banning child marriage will only decrease the number of marriages registered under the state system, but not all marriages in pluralistic legal system. And pluralistic legal system is not unique to Indonesia only. What is worse, it will not solve the core problem, which is unplanned teenage pregnancy and lack of reproductive health education tools. My case studies have showed that child marriage is often an only symptom of unplanned pregnancies outside of wedlock. So the current focus on banning or eradicating child marriage will not solve the underlying social problems. Now, I have argued that the banning child marriage is not an effective approach. And later in this presentation, I will talk about alternative solutions and policies. But for now, let us pose another question. Why is the current approach of international human rights institution to child marriage is as it is now? Why does it try to ban all child marriages, and why is the child marriage defined or marriage under below the age of 18? When I analyzed the developments of international discourse on child marriage, I understood that child marriage has started to be framed as human rights violation since around 1960s. You can read the book for the detail of the analysis, but for now, here I limit myself to say that the current international framework of child marriage has been developed through a monological process of international standard making, which lacks consideration for diverse views on what a child and a marriage mean. And the dominant discourse on child marriage has dismissed tradition as something harmful and emphasized to focus on autonomous individuals. Within this dominant discourse, autonomy cannot exist within what they see and label as traditional settings. However, sociological literature have been left this way of thinking about autonomy long ago, which is called libertarian conceptualization of agency. While a libertarian conceptualization of agency propagates to enhance one's capacity to decide on one's own life independently from so-called the traditional order, an alternative relational understanding of agency recognizes a capacity not only to resist the structure, the traditional order, so-called traditional order, but also to inhabit it. A good example of this is the recent debates over the regulations on headscarves. The debates have clearly showed us what seems like a symbol of oppression to an outsider, such as wearing headscarf, can be for a Muslim woman exercising their autonomy. According to these understandings, agency is an ability to choose by making internal reconciliations with structure. And by structure, I mean a pattern arrangement that influence or limits available choices. And in this logic, children's act of marrying, which is that considered following the structure, and their act of not marrying, which is the resisting the structure, can equally be an outcome of exercising agency, according to this relational understanding of agency. I hope I'm clear. And international advocacy surrounding child marriage is based on modernity's idea of libertarian agency and normative principle that we all, especially women, should be able to decide how to live our lives instead of submitting to the traditional, what so-called traditional order. Relational autonomy suggests that such a conceptualization of agency is only an illusion, as ourselves are all embedded in social interactions and relationships. And here, the idea that the culture is a problem for human rights is related to more general tendency to culturalize problems. It is a way to interpret women's subordination in terms of cultural practices. International institutions such as CEDAW Committee typically talk about culture as a barrier to progress, based on their understanding of culture as a static tradition. Under the label of harmful traditional practice, child marriage is paired with issues such as female genital mutilation, polygamy, seclusion, and veiling. Therefore, it is something that they also conceptualize harmful traditional practice as something to be eradicated. But this label itself is misleading. We should not simplify the difficult line between consent and coercion. Under the relational understanding, agency is an ability to choose by making internal reconciliation with structure, and the structure that actors interact with is not the essentialized culture or tradition, but the structure that people interact with to be able to make choices by reconciling with this structure is actually the persons with whom they have some sort of relationships. Bauman, in his seminal Liquid Modernity concept, suggests that in modernity, in modern world, structures do not disappear, but they are simply replaced by self-chosen ones. And structures here are essentially various relationships and social connections that an individual forms around them, and that which exists in any society, regardless of it being traditional or modern. So, in light of this understanding about structure, what can be labeled as culture, tradition, or custom is actually an essential part of people's lives, not an obstacle to realization of human rights. On the contrary, it is an essential tool for realizing human rights. In pluralistic legal systems, customary or religious laws can help external supporters of human rights to understand what their rights mean for their beneficiaries and supports these rights holders in acquiring their rights. The protection of individual rights does not necessarily lead to the protection of rights of the relational self, which considers self as one belonging to a community. And these rights to relational self often stay unnoticed within the current approach to protect human rights. When international institutions automatically dismiss what is framed as tradition from so-called the South, they fail to recognize the possibility of autonomy being exercised and existing in a social setting in the global South, which I called blind spots. This ignorance, this failure to acknowledge the possibility of autonomy being exercised in such a setting is what I call a blind spot. And with this blind spot, the human rights framework risks becoming self-defeating and failing to achieve the end goal of the very institution, which is to protect the agency of human beings, regardless of gender, race, religion, and age. And when it comes to international children's rights, which is of course a part of this international human rights structure, but they seem to have a related yet another understanding of child agency, which is based on assumptions about childhood and developmental psychology. While the CLC more and more recently acknowledge the need to respect children's agency and stimulate their participation in decision making, policies concerning children still tend to rely on a protectionist approach. Other studies on child labor and child soldiers also indicate this. And I argued that some of the international policies concerning children's rights currently fail to walk the thin line between the empowerment and protection of children. And the international children's rights scheme tend to overshadow a child agency when their decision seems wrong from the perspective of a specific socio-economic and socio-cultural background that are typical in the West. But now we come to talk about alternative policies, but how to walk this thin line between empowerment and protection of children. To talk about alternative policies, I try to give you an example that might be felt closer to you than child marriage and child soldier and child labor. Imagine that you have a teenage daughter who goes out often with her new boyfriend. One day she is invited to his house for dinner, and his parents calls you and asks if you agree with her staying overnight. On the one hand, you want to give her freedom and to be able to trust her and to be able to show that you trust her. You do not want to be seen and you do not want to be seen as paternalistic or conservative. But on the other hand, you're also worried about her. Will she be all right? Does she know enough? Is he the right kind of boy for her? And isn't she too young? So when you want to protect her, sometimes you limit the freedom she could enjoy. And balancing this dilemma is difficult and uncomfortable. Like the parents who wanders the line between giving and limiting their daughter's freedom, the discussions and policies on child marriage should also strive to balance between protection and empowerment. The current approach is too much focused on protection and therefore it should focus more on empowerment to achieve human rights and development goals. We should all acknowledge that the child marriage framework, more broadly human rights framework, can act both as a resource but also as a constraint. As we should always ask ourselves and the local right holders whether the frameworks and policies are functioning as a resource or as a constraint. So what does the empowerment-focused approach mean in a more concrete sense, and how can we make sure that the rights are being used as a resource? First, it involves more collaborative and informed decision-making. Policies for child marriage should be designed to encourage children's participation in and collaboration with adults in decision-making, where they are informed of the decision's consequences. CSO programs can better educate children to allow them to make more informed life decisions. That education include focusing on what marriage would mean in their life and how to manage their romantic and sexual lives in a way that does not intentionally limit their choices and opportunities. Second, empowerment means providing resilience-based support for married children as well. Advocacy for child marriage should invest more in stimulating children's resilience towards improving their life after their marriage. For instance, most schools in Indonesia do not accept married or pregnant students. And one of the main reasons for campaigns against child marriage is that it deprives children of educational opportunities. Then changes could occur so that married children can continue their education. Then one of the negative consequences of child marriage is lifted up. And most marital support, the post-marital support include vocational training, reproductive health support, and whatever else helps them to lead the kind of life that they want. Yeah, that's actually conclude my presentation. It was challenging to summarize my book into 30 minutes. So I will be happy, and I have a lot more to talk about. I will be happy to receive any questions and look forward to discussions.
Thank you very much indeed, Hoko. Well, we already have some questions, and I think I could probably take two of them together because they cover something quite similar. One asks you to express your suggestions for better protections of children's human rights, and I know that that's something you've already started to talk about. The other one, possibly slightly more specifically, asks, how do you think regulatory structures can be responsive to the potential harms arising from unwanted child marriage, whilst also recognizing the valid exercise of agency in some cases of child marriage?
Yeah. Thank you for the questions. They are important, and I started to talk about it indeed in the last slide. I will try to share again. Wait a minute. Yeah, so that's what I came up with as alternative policies, and how regulatory structures can be responsive to the potential harms arising from unwanted child marriage, while also recognizing valid exercise of agency in some cases of child marriage. I think it's just that in my argument is to say that the current approach of human rights institution to ban all child marriage under the age of 18 is not very effective for various reasons. and partly because there are different reasons and motivation and types of child marriage, right? So the first step, I would argue, is to distinguish between different type of child marriage and do not put all the marriage under the age of 18 as one category and say that this is bad and this is wrong. And I think it's already a big step to distinguish forced child marriage and unforced or forced or maybe constrained child marriage and agentic child marriage. I think that's already a big step. And of course, when you try to understand, when you try to draw a line between a forced marriage and agentic, the marriage based on agentic acts, you need to be able to carefully assess whether what were actually the constraints, if there were actually constraints in the decision making, in their making decision to marry. But for that, I suggested to use different frameworks to analyze their decisions, to see what kind of constraints, what kind of relational and situational constraints that they were under when they decided to marry. Yeah, so basically, I think really taking what the children are saying seriously is one thing, to be able to be responsible to the recognition of to recognize the valid experience, exercise of agency in some cases. I hope it answers your question.
Yes, and if the questioners have follow-up questions, then they can obviously feel free to put them in the Q&A. I might abuse my privilege and actually ask a question myself here, which is, you have very even-handedly talked about child marriage being an issue for male children, adolescents, and female adolescents. And indeed, I think one of the things that your book captures particularly well is it dispels the myth that there is always a young, perhaps we stereotype, vulnerable girl marrying a much older man. Indeed, that's not what you find at all. But of course, many of the human rights campaigns specifically focus on gender. Girls, not brides, not is so-called, not children, not spouses. And I wondered if you felt that the international community is making a mistake by over-focusing upon gender, or if there is some sense to it, but is there a risk perhaps that we are particularly considering that female adolescents are unable to have the agency to make marital decisions in a way that we don't make the same presumptions about male adolescents?
Yeah, thank you, Charlotte. Good point. So if you ask if I think it is a mistake for international organization to focus on the gender, focus on girls mainly, I wouldn't say so, because indeed, if you look at the number, I don't know it by heart, but if you look at the number of child brides, child bride or groom, those who are married under the age of 18 anyway, in the world, I think it's like 95% is girls, and the rest of the 5% are boys. So it makes sense to focus on girls. But indeed, we should also pay attention to the boys who are married under the 18, because they exist. And actually, there are also cases. There are also cases where the boys are decided to marry under quite some constraints. For instance, when the boy gets their girlfriend pregnant, they really feel, or their families and the girl's family and both girls' family and the boys themselves family really push to be responsible to the baby, and therefore they really feel that they need to marry. But it's also it's the social norm, right? It's a norm that when when girls get pregnant, they have to marry, but when you make a girl pregnant, you have to be responsible for it. So I've seen also many cases where the boys internalize this social norm and say themselves that, yeah, it's the only way. If you are pregnant, it's the only way to go is to get married. So yeah, for me, it's so they did internalize the social norms, and they expressed their willingness to get married. So they, of course, didn't frame it as forced, but it is important to pay attention to the social pressure that are equally applied to boys, not only to girls. Yeah, and also maybe talking about the consequences of marrying early. Of course, the girls often cannot be enrolled in school anymore when they are married, and also sometimes when they get pregnant, they are not able to attend schools. But the boys, it's also the same for boys, because again, the social norms expect them to be earning enough income to sustain their family life. So they often have to quit school to start working on things. That's what I have observed in many cases that I studied, and I think the consequences are equally also, many of the consequences that are considered unique to girls are also applicable to boys.
Thank you very much indeed. And actually, taking a question which leads quite well on from that, I would like to ask your opinion about the case where the bride decided to marry early, even against the parents' will, because she preferred to have the free and lazy life. Yeah. The questioner says, I agree to the idea that this girl gave her own full consent, but some human rights activists would say something like, the girl was not empowered enough, that she could live her own life without depending upon a man, so she preferred to marry early, and that the answer to this would be to provide more opportunity for education, to empower such girls, presumably so that they at no point in their lives, whether earlier or later, felt that they had to be dependent on a man.
Yes. Yes. So I completely agree with that. I agree that the way to go in the case in cases like Ratna's case where I described is to empower them so that they can make they are put in a situation where they have more choices and maybe not only choices in a material sense, but also choices in their mind. So they, like what you're saying, they don't need to, they can live their own life without having to depend on others, on men's, that including the mental freedom and material freedom. I agree that the way to go around, the way to go is exactly that. But I don't think this should be the this should be the way. So there are other approaches that you can take, but I'm just saying that banning child marriage doesn't help her, and maybe it will even kind of put her in a corner, because the she doesn't see herself as a victim of child marriage at all. She feels that she really made a decision to marry, and that's the life she wanted to live. So I think, for instance, telling her that child marriage is something wrong and you should not have get married doesn't help her, right? So that's one thing I'm saying. But and also that I think, yeah, basically dismissing, like not listening to her voices. Yeah, so the current approach of international human rights is that they wouldn't recognize her her exercise of agency, the possibility of her being able to exercise agency there. But I think the first step is to recognize that she can exercise her agency even in a difficult situation. But then the step comes after is to provide her with more, to try to provide her with more opportunities and knowledge so that she can have more life choices. She can have and she can see more life choices that she can choose from. Yeah, I think that's what I wanted to say.
Yes, further question here. Do you see an absolute lower age limit for child marriage? Yeah. Or would your approach look at the child-specific situation, presumably with no enforced minimum at all?
Yeah, it's a difficult question. It's a really difficult question. I got that I got that question before too. So where is the line to draw, right? I find it extremely difficult. I don't find, like from my research, I did this research for over 5-6 years, and I didn't find an answer to a lower age limit for child marriage. So I think my answer would be to really look at the specific child situation and how, especially not only the child situation, but especially how they came to decide to marry. And also, I think I find it difficult to find an answer to this question because the meaning of marriage and consequences of marriage are also different to every community, every state, or maybe every individual. So for instance, in some society, I know in some areas in Indonesia, you have a marriage when you're extremely young, but it doesn't change anything of their life. So you have marriage, but you stay, you are married, but you stay, you don't live together yet. You live with your own parents, and you go to school, and you don't interact. And only when they are above certain age, when they become adults, they started to live together and they started to have marriage life, like from the marriage as we understand it. So I think that's also that's also a reason why I find it difficult to set a lower limit for child marriage, because it really depends on what you do in however you call a marriage, right? But that would be my answer.
Yes, we have somebody who says congratulations on your research, some of which they've read already, and they find your findings very convincing. But they ask, have you looked at the culturally contingent meanings of marriage and its impact on the discussion? I think possibly you've just touched on that. They say, arguably the most important functions of marriage, legitimate sexual intimacy, legitimate offspring, economic protection for the wife, can all be fulfilled outside of marriage in Western European countries, leaving only love and self-actualization as the purposes of marriage. Could it be that opponents of child marriage tend to universalize such a concept, and that it's insufficient to account for the cultural role of marriage, for instance, in Indonesia?
Yeah, thank you. Yeah, fascinating question. I really like that. it also gives me new insights. Well, I did study that. That's actually exactly the reason why I said that. No, that's exactly what I mean by saying that the development through the child marriage, the discourse on child marriage, which is to consider child marriage as human rights violation, have been developed by monological understanding developments of child marriage, which fails to consider different views on what it means to what a child means, and as well as what marriage means. And I deal with that in one of the chapters on my book in detail, but I try to summarize what I said there. Is that marriage in the modern Western society has been conceptualized as the romantic love and between those who are responsible enough to make the decisions of two individuals, the marriage between two individuals who are responsible enough to make that decision in their life. And that is only, well, that is only one way to think about marriage, while the other way to conceptualize marriage and think about marriage is, for instance, it's more collective, that marriage is between two families instead of two individuals. And that's actually what I found interesting in this different meaning of marriage, is that some a book that I read was arguing that because the marriage became something in the modern Western societies, the marriage became something between two individuals. That's when we started to think that, okay, the marriage you cannot marry under certain age because you're not responsible enough to make that decision. While if you conceptualize marriage between two families or something broader, you make the decision together. So that's why that was one of the maybe impetus to talk about the minimum age of marriage and to raise the minimum age of marriage in the recent in recent years. So indeed, a change in the concept of marriage does have a big impact on the development of this international discourse on child marriage that considers child marriage as a human rights violation. And
Thank you. I've just noticed actually that another question in there is a very similar one, actually looking at whether you've encountered differences in the social purpose of marriage, which I think is probably what you've just answered. Again, if I could, well, first of all, if I could urge people, if they have any more questions, to type them in. We've got one remaining, but again, I'm going to interject one of my own, if I may, which is, we've got another one pop up. To what extent do you think that, I'm thinking particularly about Indonesia here, but also about Singapore, which is my own area, individual governments, particularly sort of post-colonial nationalizing governments, have pushed an agenda of wishing to raise the minimum age of marriage, not necessarily because they are influenced by an international human rights discourse, but because they see older marriage as a sign of modernity, civilization, perhaps, or at least setting themselves apart from the lack of regard which they received under colonial regimes,
Yeah.
but also because they wish to see women as economic agents and economic agents outside the home, because this is to the support of nationalistic post-colonial development.
Yeah. Yeah, good question. Thank you, Charlotte. Yes, so it is very relevant and pertinent questions and discussions it was like child marriage actually was very much a topic that has been discussed in colonial societies as well, which I know of Indonesia, but I'm sure also in other countries, that child marriage has been addressed by the Dutch government, the Dutch colonial government, and they try to eradicate, they try to reduce the practice of child marriage because they saw it as something like a sign of uncivilization. So they wanted to advance, they wanted to change the practice to be able to civilize the society in the view. And the reason why they wanted to, the conclusion at the time of the colonial society, colonialization was that they gave up because because they saw it as something that is inherently, something that's the native people, what they call, need to decide, right? It's the issue, it's some private issue of the people in the native population. That's one thing, that's one of the reasons why they gave up on, they stopped intervening in this issue. Another reason was that they didn't see it as an effective intervention to intervene in this issue because they just didn't, they just couldn't convince the local leaders of the need to eradicate this practice. And basically they gave up. But that was a conclusion. But the reason why they wanted to work on it is because indeed started to see women as an economic agent, which for them was important mission for civilization and modernizing the society, colonial society. And also the women as autonomous subjects that are women's emancipation was important mission for the colonial government. So, and then child marriage was in their eyes was an important, eradicating child marriage was an important step for women's emancipation. And another important reason why the colonial governments intervened with this issue is the population control, right? Because the child marriage issue is actually still in today's society related very much with population control. Of course, because if you marry early, you're going to have more children. It's more likely that you're going to have more children. And then it's very overlaps with the national goals and policies and programs on population control. So that was one of the motivation for the colonial government as well to intervene in this issue.
Thank you very much. I think we have two final questions now. First of all, again, someone says, thank you for your talk and your bold research on agency. They wonder if you can discuss the broader theoretical implications of your research on agency on international human rights law, particularly how this fits into third world approaches to international law, critiques of human rights.
Yeah, thank you. Yeah, good question. Application to how do I start, because that's the main thing I discuss in this book. So I am just wondering how I start. Yeah. So as I said, what I found from this case of child marriage, or how international child marriage framework talks about agency or treats agency, is that international human rights framework more broadly tend to culturalize the problems, right? So they whenever they see and act, so when they see culture as a barrier to the realization of human rights, and by culture, and they blame what they conceptualize as culture or tradition or harmful traditional practices as they blame that for the problem that they are seeing, they try to solve. And that is not helpful, because that's first, it's just simply wrong to essentialize what can be contained in what we call culture. And there's a lot of things that we are talking about when we're talking about culture, and it's also difficult to essentialize, for an outsider to essentialize and simplify what they might want to call culture. And I think it's simply wrong to just blame that and simplify this. And another thing is that by doing so, I think the international human rights framework really miss an opportunity, or fails to recognize the possibility of agency existing in what they considered or what they frame as traditional settings, right? So this really, for me, is a blind spot of international human rights framework, because the very end of international human rights framework is to enhance or to promote all the freedom and agency of our rights, the rights of everyone to be able to lead the life that they want. So basically, the freedom for all the people, regardless of race, ethnicity, religions, and where they live. But by culturalizing some problems, I think international human rights law and framework are really missing and failing to achieve this very end. So that's how I see as maybe the broader theoretical implication of my research on agency of international human rights law. And you also asked how it fits into the third world approach to international law, critique of human rights. Another thing that I could relate to in discussing this is that there's also the need to really look at what human rights norms or human rights law does in local context. There have been discussions on cultural relativism and universalism of human rights, and we have been discussing whether human rights are too universal, or whether the cultural relativist is too dismissive and too passive to try to solve the problem that's existing and the suffering that could exist in the world. There has been long ongoing discussions and debates between the cultural relativists and universalists in the international human rights law debates. But I think instead of discussing that in a very abstract way, what we can do is to recognize that whatever human rights law says, or looks or as prescribed on paper, it's always the effects of human rights. What human rights do are always dependent on the local context where these norms and rules are applied, right? So I think in discussing what human rights should be like, we need to think more about, we need to study more, look at more what human rights do in each context, because it's always tailored, it's always used differently by local agents, whether it to be NGO workers or judges or people who are educated or who are informed about the human rights that they have. It's interpreted and applied quite differently in different contexts. So maybe that's what I wanted to say.
Yes, no, indeed, I think that's one of the strengths of your book, that you have done so much field work here, that you do provide a very solid and concrete example of what, as you quite rightly said, can be quite a theoretical debate, and has possibly suffered from an excess of theory over practical application and practical interrogation. The very last question I'm going to take asks you about your opinion on children's human rights in Afghanistan, and I appreciate that's not your region, so perhaps I could broaden that out slightly, because I know you are now in the post-monograph stages. Well, hopefully you're still basking in the fact it was published last week, but I know you are now looking at more countries. So perhaps very briefly, you could talk to us about what you're looking at now in regard to countries outside Indonesia and children's human rights, either more generally in the ASEAN region or wherever you particularly are looking.
Thank you, Charlotte, and for broadening the question as well. What's my opinions regarding children's rights in Afghanistan or other areas outside of Indonesia? What can I say? So you, Charlotte, you suggested that I talk more about my research after this research. Yeah, if I may, maybe I can start by that. So what I am interested in relation to this research, but also after this research, is that it's still the agency of children, and especially their right to sexual autonomy. And this issue has been not discussed. This has, from what I know, this is quite the children's rights, children's agency to something like, to, for instance, the medical treatment, what the informed consent of children to medical treatment, for instance, has been discussed, and the CLC has been talking about the right to be heard, evolving capacity, and to whatever they are consenting to, whatever that they are making decision about. But from what I know, international, so the CLC, including CLC International Framework, have been quite limited, put it mildly, to children's right to sexual autonomy. I think it's just a very uncomfortable topic. And that's what I'm interested in, and for that reason I'm now studying the age of consent in Indonesia, in Japan, in the Netherlands, and I'm doing the comparative research. What else can I say? So yeah, I think that's one of the things. So children's rights has been studied, has been maybe increasingly paid attention to, and I'm happy that there's also Children's Rights Network at Oxford, and I hope to keep engaged with this network as well. But the right to sexual autonomy is understudied from my view. So that's how I want to expand. Sorry, I'm not really answering the questions that's the person asked, but if you are interested, I can also put you in touch with a colleague who is doing research in Afghanistan, not on children's rights, but there are, in my institute, there are people who work on Afghanistan. So just send me, if you have particular questions, you can send me email.
That's very kind of you indeed, and indeed I would second your thoughts on the difficulties and indeed the potentials of studying in an age of consent, because that is indeed the subject of my own thesis. It's a subject close to my heart. So thank you very much, Hoko, indeed. I have put in the chat the details of your book. I've noted that it's currently part of the Routledge Black Friday 30% off sale. So there's no idea when that ends. So thank you very much, and I will pass back to the Bonavero team to wrap up. Oh, and we've just had a note that if you have any feedback, please write to the Bonavero. To register for future events, there's a link, and that this event today will be uploaded as a recording, so you can share it with anybody who wasn't able to join us today. So thank you very much indeed, and I hand back to the Bonavero.
Thank you everyone for joining, and thank you, Hugo, and thank you to the Oxford Children's Rights Network. We, as mentioned in the chat, we'll be uploading the recording, and you can write to us for any feedback on the webinar, and you can also register for any future events on our website. Thank you everyone, and have a good day. Thank you. Bye.